Welcome. Welcome to A Taste of Justice with Professor Angela Mae Kupenda. Today we're going to talk about conversations from the back porch, gender and race and equal protection under the Equal Protection Clause. Now, you see I'm on the back porch now. And I'm sitting on the back porch. I mean, the sun is overcast. Hopefully you can see me. The sun is quite bright. But I'm on the back porch for one reason that I consider to be very positive, and another reason that just gives me pause. Let's talk about the positive reason first. When I was a little girl growing up, I enjoyed going to my grandparents' home in Port Gibson, Mississippi. And on the back porch, out in the backyard, was an exciting place to be. I would listen to my grandmother and my mother and her sisters as they had conversations. They would be washing the clothes over they had a big pot, a big large black pot where they would heat the water with fire under the pot. They would be picking food from the garden, picking vegetables, occasionally getting a chicken or two for dinner. You know what that means. But all of this was going on in the midst of conversation as they discussed their lives, they discussed race, gender, family, and I enjoyed sitting in the corner listening. That's the good memory. The thing that gives me pause why I came to the back porch is this, that it seems sometimes that in looking at the Equal Protection Clause, both by the court and in general society, looking at inequality, it seems that the focus is often on race because there's so much going on there in terms of race inequality. I agree with that. But sometimes it seems as if it leaves the discussions about gender out on the back porch instead of bringing them all into the conversations about inequality related to race and related to gender and other characteristics. I'm going to add also and say this, that sometimes it seems that in the living room, we may have the conversation about race, and we may also have a conversation about gender. But the conversation about race, with so much going on, the focus is often on the Black male experience. The conversation about gender, it is often about the white female experience, which means left on the back porch is often the experience about the inequality experienced by Black women and other women of color in America. So I came to the back porch both for that positive memory about gendered experiences on the back porch, and also about the thing that makes me go, and how can we all move? How can we move all of us to the place of the preamble of the Constitution to establish justice for all of us, because we all are we the people. And I'm not saying don't focus on racial equality, we must. I'm not saying don't focus on gender or class equality. I'm just saying more learning, more discussion, more debate. It's better, it's good. So today I want to talk with you just about a few principles related to gender and the Equal Protection Clause. And let me just say, I have my notes to try to stay on point if you see me looking down sometimes. Let me just say that my interpretations of these opinions are my own. I'm a professor at Mississippi College School of Law, but I tell you that for identification purposes. Our interpretations and views expressed here are mine and are not to be ascribed to my school or to my students. So let's get started. We recently celebrated the 100-year anniversary of women receiving the right to vote. Remember that after the end of slavery, Black men and Black women and white women and some white men and others had worked to try to bring voting rights to all. But the 15th Amendment only gave voting rights to Black men. It wasn't until 1920 that women received the right to vote. And then it was many, many years later with the 1965 Voting Rights Act that many actually got to experience exercising that right to vote. Now, the court treats unequal treatment based on gender in some different ways than it treats unequal treatment based on race. And I want to talk about some of these principles for you today. First, going way back and maybe continuing today, the court had a limited and flawed view of the real life experiences of women. There's this case from 1873, Bradwell, that's mentioned at the bottom in the notes. Bradwell, where a woman wanted to practice law in her state, but the state did not allow. It did not allow for women to practice law. So she brought a lawsuit saying her state was treating her unequally. Unfortunately, she lost. The court determining that the state could make those kinds of distinctions back then. Now, one of the concurring opinions really gives me pause. In the concurring opinion, one of the justices said this. I'm going to read it to you. I'm going to read it. It's a little warm out here, but that's okay. I'm going to read it. The court said she didn't need to practice law. The court said the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. The paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator. Now, this justice had a very limited view for many reasons. First of all, he said it's the law of the Creator. I don't know about that because there's so many women in the Bible. Yes, I go to Sunday school. There are so many women in the Bible who had successful occupations in addition to being wife and mother. And number two, when the justice wrote this, many women were already employed and working to help support their families. There were white women who were working and employed, and truly Black women we were right out of slavery. Surely they had been working and were wives. Well, they may have been wives, but the marriages during slavery often were not recognized. So here, now the justice said some other things too. He said, of course, there are exceptions, but the law does not have to bend to exceptions. The law applies to general, and in general, he thought women did not need to be practicing law. Now, I'm sure my students, all of them are so excited that this holding was overturned because women do bring a wealth of experience to the profession and to the classroom. And I'm not just saying that because I'm a woman too. I'm saying that because I value diversity. Okay. Secondly, the court often treats unequal treatment about race different from the way it treats unequal treatment based on gender. Remember, go back and look at the clip about scrutinizing governmental actions. We said generally there's this low level of scrutiny. But in Caroline Products footnote 4, the court said for some things you use heightened scrutiny. And I told you that there was one in the middle that I would tell you about later, and that's the level of scrutiny the court assigns for gender unequal treatment. So it's almost like the court is saying it's not as serious. Is that what the court is saying? That it's not going to scrutinize that as much. But that's what the court has done. The mid-level test is called intermediate or mid-level, and government has to have an important governmental interest, and the unequal treatment must be substantially related to that interest. Now, before the court got to that point, the court took a look at what determines if a category or a classification is suspect or not. A suspect classification means that the court would use heightened review. Here it only heightened to the middle. It didn't heighten all the way to strict scrutiny. But the court said that, look, it is so hot out here, but look, I'm gonna ride it out on this back porch because my grandmother and mother and my aunties did, and me as a little girl. So we're gonna be just fine. Just don't let my sweating and fanning bother you. I'm gonna go on. Okay, so the court said you look at a number of factors to determine if there's a suspect classification so that you raise the scrutiny from low level to mid. Here, not to heighten, not all the way to strict, but it went from low to mid. The court says, well, first, there's a long history of discrimination against women and continuing discrimination. Second, the court said women have a highly physical characteristic that would make discrimination based on that characteristic happen more frequently. Third, the court said this is an immutable characteristic, one that cannot be removed. Fourth, it says that often there's unequal treatment based on a woman being a woman, and it has no relationship to the job or whatever is going to own. So why is the government doing this? And then it says that it struggled a little bit as to, going back to Caroline Products footnote 4, where the women make up a minority. We know that women make up about 50%. So do women make up a minority numerically? No, but the court said women make up a minority of power, a minority of political power. The court also says that it takes into consideration that the discrimination against the unequal treatment against people based on race is of a different root, it thinks, than the discrimination based on gender. The court said that often women were discriminated against because they were being put on a pedestal or in a cage on a pedestal. They were being protected, not because they were being disliked. So ultimately, the court says it's going to use this mid-level scrutiny. But do you know what the case was where the court went ahead and articulated it? Do you know who was suing? The case Craig versus Boren. It was not women suing, it was men. The men were upset because they could not buy beer until they were 21, but women could buy beer at 18. So they brought suit. So the court actually gave gender this full analysis in a case where it was not even women bringing suit, but rather it was men bringing suit, saying that they were being discriminated or treated unequally based on their gender. Now, another point you have to remember is that the Equal Protection Clause says that government should not treat similarly situated individuals unequally. With race, the court says, regardless of your color or your race, we're all similarly situated. With gender, though, the court says men and women are different. And in some situations, they are not similarly situated. The tricky point becomes, are they really different in some instances? Or is the court just using stereotypes? That's a point that you'll want to watch for. Now, just like we have Brown versus Board of Education, we have MUW versus Hogan, where Mississippi University for Women wanted to deny men access to the nursing school program because they were men, and the court said no. And Virginia Military Institute, VMI, where they did not want to admit women to that program. Now, this wasn't a, I guess you would say, military school. People enrolled were not members of the military. They just were receiving this training. So the court said, the state set up a school that the court said was inferior, and therefore women had a right to attend VMI, with the court using the mid-level review. Now the court left open a couple of things. The court left open if it was possible, let's say a middle school, public school decides that it wants to separate the girls and the boys for math or for science. Would that pass constitutional muster? I don't know, the court hasn't addressed it, but some schools have been doing it for a number of years. Or say, for example, this is something you hear about every so many years, where there are individuals considering having a women's only law school. Would that pass constitutional muster? Could it meet that mid-level test if women could go to other schools too, but there was a special law school set up only for women? I don't know, the court, I don't think such a school has been yet established, but it's something interesting to think about, how the court may tolerate certain governmental differences for gender that it likely would not tolerate for race. Let's see, the last point I wanted to make has to do with affirmative action. You've probably heard of affirmative action. Some people call it reverse discrimination, diversity and inclusion, all kinds of things. What you call it probably reflects what your viewpoint is. Basically, the court said diversity is a compelling governmental interest, but the programs must be narrowly tailored as related to race. And I give you a couple examples at the bottom. But gender is evaluated under a mid-level. So theoretically, it is possible that affirmative action program for women could be upheld where one for racial minorities would not, because it would be under strict scrutiny. That sounds a bit odd, doesn't it? You know, some justices have argued that the two should be treated alike, race and gender. That would make things more simple, more direct, and it would treat inequality as inequality. I remember way back in 1990 when I was a law school student and we were discussing some of these matters. I asked my teacher, I said, now, if racial affirmative action is scrutinized under strict and gender is only scrutinized under mid, what if there was an affirmative action program just for Black women? of women of color, what would it be scrutinized under? Aren't Black women also women? And aren't Black women also Black? So having these two different levels, it takes us back to this thing about invisibility and the back porch. The back porch, we don't give full consideration to certain issues. Some topics are left outside. That may be a broader stroke, maybe, just getting to the preamble, where we, the people, can establish justice for all. Again, this is A Taste of Justice with Professor Angela Mae Kupenda. And I've enjoyed this visit with you from the back porch, but right now, I'm gonna head to the front porch, and maybe to the inside of the room. Thank you. You take care.